The EB-5 Reform and Integrity Act of 2022. Greater protections and lower risk for EB-5 investors. EB-5 overview and important changes in 2022. Thanks to a recently enacted federal law, EB-5 investors will have greater protections that increase the likelihood of success with lower risk. In this informative video, we discuss the benefits to investors in the EB-5 Reform and Integrity Act of 2022. The EB-5 Immigrant Investor Program enables qualified foreign nationals to obtain permanent residency in the United States by making a job-creating investment in a for-profit U.S.-based project or business venture. The EB-5 program is administered by U.S. Citizenship and Immigration Services, or USCIS. EB-5 investors face two types of risk: financial risk and immigration risk. EB-5 investments have two kinds of risk: financial risk and immigration risk. Financial risk is the probability that the investor will recover their capital investment in the future. Immigration risk is the probability that all required jobs will be created and the company that receives the investment will fully comply with the EB-5 program rules so that the investor can ultimately remove conditions on their residency and obtain a permanent green card. These risks exist for all EB-5 investments. Companies cannot guarantee that an investor's money will be returned. Likewise, there is no certainty that the EB-5 project or business venture will create enough jobs and remain in compliance with the rules enforced by USCIS. Therefore, it is the duty of prospective investors to choose carefully to minimize their exposure to financial and immigration risk. Why new EB-5 integrity measures were needed. From the creation of the EB-5 Immigrant Investor Program in November 1990 until March 2022, investors had few protections from the government. U.S. immigration law had no provisions to ensure transparency, prevent fraud, and demand accountability from EB-5 industry participants, such as regional centers and EB-5 project sponsors. As a result, EB-5 investors have too often been the victims of mismanagement or neglect. At the same time, investors could be denied U.S. residency or lose their residency if the regional center or project sponsor violated the EB-5 program rules. In many cases, innocent investors were denied green cards despite acting in good faith. And the adjudicators at USCIS, who are bound by the agency's strict rules and the limitations of federal law, had no option but to deny investors' applications. The U.S. Congress sought to address these problems with robust new regulations included in the EB-5 Reform and Integrity Act of 2022, or simply the 2022 EB-5 Act, which is part of an omnibus appropriations bill signed into law by President Biden on March 15, 2022. Increased transparency and EB-5 regional center oversight. The 2022 EB-5 Act mandates greater transparency and accountability and provides certain protections to EB-5 investors. Together, these new regulations meaningfully reduce the financial and immigration risk to foreign nationals seeking U.S. residency through investment. The new regulations increase the federal government's oversight of EB-5 regional centers and impose significant penalties for non-compliance. Regional centers, which are licensed by USCIS, are now required to submit more detailed annual reports with proof that investors' capital was properly allocated to sponsored EB-5 projects. Detailed financial reports must also be available to investors. Regional centers are also subject to 5 yearly audits by USCIS. To facilitate transparency and discourage fraudulent activity, new commercial enterprises, or NCEs, sponsored by EB-5 regional centers must either 1. Provide annual audited financial statements to investors, or 2. Use an independent third-party fund administrator. Audited financial statements are prepared by certified public accountants, or CPAs, who are state licensed and are bound by a strict code of ethics. Fund administrators are known to be highly selective and only accept as clients projects that are credible and meet stringent criteria. This provision of the 2022 EB-5 Act will do much to make regional centers and NCEs accountable to individual investors and other stakeholders. EB-5 investors can find peace of mind with the knowledge that their capital has been properly allocated to the job-creating purpose described in the project's offering documents. Following the resumption of the EB-5 Regional Center program in May 2022, regional centers will be required to submit a project request to USCIS before investors in a sponsored NCE can file their I-526 petitions. While the request does not have to be approved before investors can file, the request must be submitted in advance so that USCIS is aware of the EB-5 investment offering and the project details. This requirement encourages regional centers and their sponsored EB-5 projects to take a proactive approach to compliance, as investors and their attorneys will ask for proof that the project request has been submitted. Another major policy change is the requirement that USCIS conduct in-person site visits of EB-5 financed projects to verify the occurrence of legitimate business activities. At the same time, USCIS will increase its scrutiny of EB-5 regional centers and their sponsored NCEs to ensure that bad actors are not involved in EB-5 investment activities. Individuals with criminal convictions in the past 10 years or who have been involved in cases of fraud with liability of more than $1 million are disallowed. Material changes to EB-5 investment projects. In the past, material changes were a common reason for green card denials and revocations. In the context of EB-5, a material change has historically been understood to mean a significant and unnecessary deviation from the business plan of an EB-5 financed project or business venture. For example, if the business plan describes construction of a new hotel and the developer instead builds a shopping mall, this is a material change. However, USCIS has denied or revoked EB-5 green card petitions due to much smaller changes. While the 2022 EB-5 Act does not explicitly define a material change, it places responsibility on regional centers to notify USCIS of a material change and whether investors have been notified. It remains unclear how USCIS will adjudicate I-526 and I-829 petitions following a material change. But the new requirement should be a disincentive to developers to make major changes to EB-5 projects, as regional centers will likely prohibit such actions in their loan agreements and affiliation contracts with NCEs. Protections for innocent EB-5 investors. In the past, termination of a regional center's license by USCIS meant certain doom for the I-526 and I-829 petitions of investors in their regional centers' sponsored NCEs. The existing rules provided no pathway to green card approval, even if the investors had no responsibility for the regional center's actions that affected the termination. The 2022 EB-5 Act includes provisions that allows, under certain circumstances, innocent investors to affiliate with a different regional center or NCE and continue the immigration process. Protected investors will not lose their USCIS priority dates, and eligible dependents on the same petition will be protected from aging out. EB-5 regional center fee increases and fines for non-compliance. USCIS now has the right to impose on a regional center a fine of up to 10% of its raised capital, debar individuals from participating in the EB-5 program, and suspend or terminate a regional center's license. These severe consequences represent a significant business risk to regional center operators. Regional centers and NCEs can no longer take a haphazard approach to EB-5 compliance. Importantly, regional centers are now required to pay USCIS an annual fee of either $10,000 or $20,000 depending on the number of EB-5 investors in the regional center's sponsored NCEs. Individual investors will make a one-time contribution of $1,000 when filing an I-526 petition. These fees will go to a new EB-5 Integrity Fund to be maintained by the U.S. Treasury. The purpose of the Integrity Fund is to pay for USCIS's investigation and enforcement activities. fees paid to EB-5 investment promoters will be disclosed. Regional centers are not the only EB-5 industry participants subject to new regulations. Companies that promote EB-5 investments outside the U.S. must now comply with rules designed to protect EB-5 investors. These promoters, who may be called migration agents or other names, identify and recruit high-net-worth individuals seeking U.S. residency through investment. They often collect a fee from the investor, and they might also receive a referral fee from the regional center or NCE. Because these companies operate offshore, they are outside the purview of U.S. securities regulators, and U.S. immigration authorities have had limited ability to protect foreign investors from fraud and other malfeasance. The 2022 EB-5 Act gives USCIS some power to regulate promoters outside the U.S. Companies or individuals offering EB-5 investment outside the U.S. must now register with USCIS, meet certain criteria, and adhere to applicable regulations. Additionally, promoters must now disclose all fees to investors. Increased flexibility to demonstrate required job creation reduces immigration risk. An additional benefit to investors in the 2022 EB-5 Act is flexibility for job creation. Now, when EB-5 investors file Form I-829 to remove conditions on their residency, it will no longer be necessary to prove that all 10 jobs were created. Instead, investors must show only that they are actively in the process of creating the employment required. Within 12 months of submitting the initial I-829 petition, an investor can file another petition with evidence that the jobs were created. This provision provides much-needed relief to investors in projects that are delayed, possibly as a result of the COVID-19 pandemic or other factors. Conclusion: EB-5 projects will be safer, but higher compliance costs will be passed on to EB-5 investors. The immigration policies described in this video provide many benefits to investors. At the same time, the compliance burden on regional centers and their sponsored projects has increased considerably. This will inevitably result in increased operating costs for regional centers and NCEs, which will be passed on to investors in the form of higher subscription fees and lower financial returns. The lower return will likely correlate to lower risk, which has long been a top priority for EB-5 investors. About EB-5 Affiliate Network, EB-5AN, and available EB-5 projects. EB-5 Affiliate Network, or EB-5AN, is a leading EB-5 investment fund manager, regional center operator, and consultancy. Our more than 10 EB-5 regional centers sponsor more than 2,000 EB-5 investors from more than 60 countries. Many of the practices mandated in the 2022 EB-5 Act have been in use at EB-5AN for many years. Indeed, our firm has long been ahead of our competitors and ahead of regulators in innovating best practices for EB-5 investment that reduce both financial and immigration risk for our EB-5 investor clients. Prospective EB-5 investors and others who have questions about the EB-5 program and available investments should visit EB-5AN's website at www.eb5investments.com or send a message by email to info@eb5an.com.